Should you go to trial or not? If you're facing criminal charges in Indiana, one of the biggest decisions you're going to have to make is whether you want to take your case to trial. There are a lot of factors to consider. And today I'm going to break down some of them so you can know what's going to go into you making an informed decision. So the first thing that we need to think about is, what are you actually charged with? You need to understand what you're charged with. Are you facing a misdemeanor? Are you facing a felony? Right? The severity of what you're charged with is going to play a huge role in whether trial is the right option or not. A low-level misdemeanor, it might make sense, even if you're likely guilty, for you to go to trial if there's not a favorable plea on the table. But if you're charged with a really serious felony that carries really heavy penalties, fighting the case might be necessary, especially if you maintain your innocence. But on the flip side, your risk of going to a jury trial is exponentially increased. So these are things that you have to consider. What are you charged with? What's the severity of what you're charged with? How many years could you be facing if you were to go to trial? Another thing is, what is alleged to have happened? What are the prosecutors saying happened? Are there witnesses? What did they say happened? Was there a police investigation? What do the police believe happened? For example, if you're charged with domestic violence, but the alleged victim isn't cooperating with the state, maybe they're cooperating with you. Maybe they've told the state they're not going to cooperate. Maybe they're not going to show up to depositions. They're not going to show up to trial. That's going to significantly weaken the state's case. On the other hand, if you're accused of a crime and there's strong evidence against you, maybe it is a domestic battery and that alleged victim wants to pursue those charges and they're going to testify against you. The facts of your case and the witnesses and the evidence involved makes a big difference. And going into that, is there evidence, right? Are there reliable witnesses that are going to be able to testify? Is there video footage of what's alleged to have happened? Is there physical evidence linking you to the crime? DNA, blood, forensics, right? Are there inconsistencies in the state's case? Are there, if this is a case where injuries are alleged to have occurred, do they have photographs of the injuries? Do they have hospital records of injuries? Your attorney needs to carefully review all of this evidence and determine, is there enough reasonable doubt to win a trial? Is the evidence weak? Is it circumstantial? Do you have a strong chance of success based on the evidence? Another consideration for whether or not you should go to trial is the plea. Plea deals are a major part of the decision-making process. It's a major part of what we also do. The prosecution might offer reduced sentences in exchange for a guilty plea. So we have to think about, is this plea agreement fair? Would you avoid jail time, for example, by taking this plea? Does the plea bargain carry long-term consequences? A criminal record that could affect your employment or your housing. It could cause you to lose your gun rights. It could cause a number of other things, right? If the plea is reasonable and the risk at trial is really high, it might be in your best interest to take a plea. If the plea isn't better than what you would receive by going to trial, or if the plea is not very fair to what's alleged to have occurred, or if the plea that is being offered isn't something you want to consider because you maintain your innocence. These are all things that we have to think about. So what are some other factors? Immigration, job loss, witness issues. There are a number of personal factors to think about when going to trial. Immigration and deportation can be a reason that some people want to go to trial. You might not be able to take a plea for fear that you'll lose certain statuses you have. Maybe your job requires you to have a clean record. You're a teacher, a nurse, a government employee, and even a misdemeanor conviction could end your career. Witness issues are also important. If key witnesses for the prosecutor aren't going to be credible, they won't be reliable, maybe they refuse to testify, it could be a good reason to take your case to trial. These are all things that your attorney would speak to you about, and you're going to weigh these things when you make your decision. Next is, do you do a jury trial or do you do a bench trial? And this is a major decision, and it's a decision that you don't have to make early on, but it's a decision that your attorney needs to discuss with you early on. In Indiana, most felony and misdemeanor cases allow for jury trials. If it's a misdemeanor or a level 6 felony, you get 6 jurors and an alternate. If it's a level 5 felony or higher, you'll get 12 jurors and an alternate. A bench trial, on the other hand, means the judge alone decides guilt or innocence. A jury trial could be better if you need multiple perspectives, especially if the case involves a lot of emotional factors. A bench trial can be better if your case has very specific legal issues that are very complex and maybe jurors are going to struggle to understand them, whereas a judge will understand them. Knowing the judge's tendencies can also be helpful. Some judges are more lenient. Some judges are very prosecutorially friendly. Your attorney is going to be able to advise you on whether or not a jury or a bench trial is your better option. Deciding whether to go to trial is never easy, and every case is different. So you need to consider everything: the charges, the evidence, the plea offer, the personal factors, witnesses, whether or not you want a bench or a jury. All of these things are things you need to consider. If you're facing criminal charges in Indiana, making sure that you consult with experienced attorneys who are comfortable going to trial and know what to look for and can assess the strengths and weaknesses of your case is going to be very important. So if you have questions, drop them in the comments below. Don't forget to like and subscribe for more legal insight. If you've been charged with a case, you want to know whether or not to go to a trial or not, call us at 317-632-3642. And remember, always plead the fifth.